Good evening and welcome to tonight's program. My name is Robert Pine. I'm director of the Norman Miller Center for Peace, Justice, and Public Understanding at St. Norbert College. We are very pleased to co-sponsor tonight's program with the Menard Center for Constitutional Studies at UW-Eau Claire and the Menard Center for the Study of Institutions and Innovation at UW-Stout. Tonight's program was originally intended as the keynote presentation for an annual symposium hosted by the Center for the Study of Institutions and Innovation at the University of Wisconsin-Stout. Under the direction of Dr. Tim Scheel, the mission of that center is to promote the study and discussion of civil liberties in related institutions, whether they be governmental, civic, business, social, scientific, or religious, through scholarly inquiry, educational activities, and community outreach. Tonight's program, Fight Like Hell, certainly fits that purpose. As we heard repeatedly during last month's impeachment trial of former President Donald Trump, incitement to violence is not protected speech under the First Amendment. But what is incitement? Since 1969, the standard legal definition has been drawn from a Supreme Court case, Brandenburg versus Ohio. By that standard, incitement is to encourage other people toward actions that are imminent, intended, lawless, and likely. After over 50 years, should this standard be reconsidered? With its emphasis on the context for dangerous speech, is the Brandenburg standard still relevant in the internet age? What is the meaning of incitement in 2021? These are some of the issues to be discussed by tonight's panel. We're delighted to welcome Dr. Joanne Sweeney, Professor of Law at the Louis D. Brandeis School of Law, University of Louisville. Dr. Eric Casper, Professor of Political Science and Director of the Menard Center for Constitutional Studies at UW-Eau Claire, and Dr. Alan Beagle, Professor of Political Science and Public Administration at UW-La Crosse. Each panelist will speak for about 10 or 15 minutes, and then after that, we'll give them a chance to respond to each other, and then we'll open it up to questions from the audience. If any of you have questions or comments for our panelists, please submit those through the question and answer feature at the bottom of your screen. And then some of our fantastic student staff here at the Norman Miller Center will be watching those questions, and they'll pass them on to the panelists later in the program. So let's get started. We're very pleased first to welcome Dr. Alan Beagle, who teaches constitutional law at UW-La Crosse. Professor Beagle, welcome.
Good evening to all of you. It's very hard to summarize this most elusive concept. And I'm going to begin with a very famous passage that all of you know from Masters v. Patton, Judge Learned Hand. Speech is both a key of persuasion and a trigger of action. We have to begin over there. We don't know if words will become more persuasive or more triggers of action because we can't see into the future. And so as long as speech is not prohibited, we run the risk that our words will be part of the marketplace of ideas and arenas of knowledge, or they will put nasty thoughts in people's heads and perhaps to act on. We never know in advance. So we begin in 1917 with Judge Learned Hand's famous position. Since 1917, the court has had several famous cases on when speech should be prohibited, at what point does it become a trigger of action, and the interests of societies to limit that speech. And I'll just quickly go over the few main cases to segue into Brandenburg. We had the Schenck case in 1917, S-C-H-E-N-C-K versus United States, which sounds funny in modern times, but Charles Schenck operated out of Pennsylvania. And we had a conscription law in 1917 when we entered World War I, and Charles Schenck thought it was a capitalistic war. We shouldn't be involved in World War I. It'll only enrich the munitions people. So he mailed about 15,000 leaflets to men who said women weren't yet eligible to the draft, but he mailed about 15 leaflets out to people whose names he got in telephone directories, encouraging not to enlist, which was against the 1917 law. Don't enlist in this war because it'll only enrich the munitions and wealthy people. Now, some people might act on that and some not. 15,000 odd leaflets. It's not a 15-second reaction. You read it, you think about it. Maybe this leaflet makes sense. Maybe it doesn't. Maybe I'll enlist. Maybe it won't. Is it a threat to society? But the court made two interesting points in Schenck. Number one, that speech in wartime means something different than it does in peacetime. And then the court said, number two, that the standard we're going to use is clear and present danger. The famous words used ever since, clear and present danger, is the content of the speech likely to produce an imminent threat to society? Whatever imminence might mean, is it likely to bring an imminent threat to society? It could happen immediately, could be tomorrow. At some point in the near future, is it likely to, the content of the words likely to pose an imminent threat to society and create a serious enough danger where the speech should be curtailed? And we didn't get a clear definition of clear and present danger. Again, the court's basic position was that there might be a time when the content and intensity of the communication is such where it could present unrest or perhaps unlawful action in the country, and at some point in the immediate future, and it would be better off if these words were censored. And ever since Schenck in 1917, the court has wrestled with when speech could be curtailed. When does it reach the level of a clear and present danger? You had the Whitney case in 1927, Whitney v. California, 1927. And at that time, there were probably communist parties in all 48 states, California being one of them. Charlotte Whitney was a major leader in the American Communist Party, and she met with a group in California, and they would discuss communist philosophy, Marxism, and the goals of communism versus capitalism. It was intellectual, but one of the tenets of capitalism is the eventual overthrow of imperialistic forms of government. In theory, that's in capitalistic Marxist philosophy. Our goal is to overthrow capitalistic forms of government by force if necessary. Does that present a danger to the United States? I don't think so. But the court took the position of suppression of the speech in the Whitney case in 1927, where the court said, and I'm quoting, if the content of speech itself is such that it might tend to incite to crime, again, to use the court's own words in 1927, that the content of the speech might tend to incite to crime, it might disturb the public peace, then it can be suppressed by government, in this case, California. No one quite knew what that meant. Any speech is potentially able to do that, tending to incite the crime, tending to disturb the public peace, tending to be inimical to the public welfare. It could be anything. But the court erred on the side of, when in doubt, to censor, and Charlotte Whitney and her group were censored. There was one other case in the Dennis versus United States in the 1950s. Maybe I should go into it, but I only have 15 minutes. So that was a wartime case. It began in wartime, and the rules of the game for the First Amendment are different in wartime. So I'm going to pass on Dennis now. Maybe one of my colleagues will pick it up. But anyway, before we get to Brandenburg v. Ohio in 1969, we have probably 6, 7, 8 key cases on the subject. We don't have time to get into all of them, starting in 1917. And again, 6, 7, 8 cases. What is clear and present danger? The court gave us a working definition in Schenck. The court has tried to fine-tune it and redefine it since 1917. I don't think it'll ever end. And now we get to Brandenburg in 1969, Brandenburg v. Ohio, and I'll be quick because there was a time factor. I guess it seems outlandish from today's times. His name was Clarence Brandenburg, and his business card said something like high official in the Ohio chapter of the Ku Klux Klan. And the Klan had a very high membership in Ohio at the time. It was June 28th, 1964. And Clarence Brandenburg appealed to a racist farmer, may we rent your property, again on June 28th, 1964, may we rent your property to hold a Klan demonstration. And I don't know what the Klan paid to the farmer for it, but the farmer said yes. It was in Hamilton County in Ohio. It wasn't a big deal by today's standards. About a dozen Klansmen met. And there was a large lit torch in the center, and then the 12 odd Klansmen paraded around it in their full attire, or regalia, I'm not sure which one. They paraded around it, and they were chanting various things. And then eventually Clarence joined the group. And he made an announcement, because bear in mind that this time you were getting the Civil Rights Act of 1964, the Voting Rights Act of 1965. Dr. King was making statements about race, affirmative action for previously disadvantaged minorities was getting on the radar screen by the late 60s. And Clarence Brandenburg addressed the crowd of about 12 Klansmen. This was filmed, by the way. They invited a camera crew from a local TV station to come, and there was a camera crew there. And Clarence Brandenburg said at the end of the demonstration that, well, it was a white supremacist speech. He said that we are not an aggressive organization, but if Congress, the president, and the Supreme Court continue to take actions which are making white people subservient, then we are going to have to stand up for what we believe in. And Clarence Brandenburg said, we're going to have a larger audience. July 4th was only a week away. We hope to have several thousand people at a Klan march in Congress. On July 4th, we're going to go down south and we're going to have Klan marches. We expect a large following. The president, Supreme Court, and Congress are issuing too many statutes that whites feel are depressing their status. It'll be the rise of, and the word people of color wasn't used at that time, that if this trend keeps up, people of color are going to overtake American society with these preferential laws, and white people are not going to take it. And it was a white supremacy speech. Was it a call to action? I don't think it was, and the court didn't either. I think Clarence Brandenburg was commenting on public policy. He obviously took issue with the Civil Rights Act of 1964, Voting Rights Act of 1965, Housing Act of 1968. Some statements President Johnson was making about race. He was disagreeing with the trend in public policy, in my opinion. Was he advocating unlawful action? I don't think so. The court didn't think so either, but the court believed it was time to update the Schenck definition of clear and present danger. And it was outlined very clearly at the beginning of this talk, but I'm going to be more explicit, and that should take up my 15 minutes, because it's very relevant to the January 6th speech President Trump made, and I think he cleared the bar easily, but that's neither here nor there at the moment. You know what the court said in Brandenburg in 1969? The court told us, number one, that mere advocacy per se is constitutionally protected. If you want to advocate a position, if you want to advocate disagreement with public policy, in and of itself, that's protected. But if you are inciting to imminent unlawful action, that is not protected. That is not speech, that is unlawful conduct, and unlawful conduct is not protected by the First Amendment. So if you're discussing public policy, just in the abstract, I don't like what this president's doing, I don't like this law, I don't like that Supreme Court ruling, I don't like the trend in current society. In and of itself, that's protected under the First Amendment. That's the marketplace of ideas. But if the content of speech elevates to where the speaker's tone and words are inciting people to imminent, IMMINENT, inciting people to imminent, in the near future, lawless action, that is not protected under the First Amendment. It's a very hard line to draw. But the court in Brandenburg established several criteria, and I want to go through them with you to segue into the next speakers and eventually former President Trump. And for this, I'm going to quote from Brandenburg. This isn't the time to paraphrase. Where the court wrote in Brandenburg, the mere teaching of a resort to force or violence is not the same thing as preparing a group for violent action and steeling it, STEILG, into such action. The mere teaching of the moral propriety or even the moral necessity for a resort to violence is protected. However, if the speaker is preparing a group for violent action and stealing it to such action, again, STEELING, stealing it to such action or steering it to such action, that becomes a call to violence and not mere disapproval of government policy. And then it becomes unlawful conduct. But then in Brandenburg, the court added that in order to ban the speech, number one, again, the speaker has to cross a certain threshold beyond mere criticism of government policy and encouraging listeners to engage in imminent unlawful action, whatever imminence might mean. But then Brandenburg went on to say that there has to be a likelihood that imminent lawless action will occur. There has to be a likelihood that it'll occur. This is likely going to take place. It's not an abstract possibility. It likely is going to happen. The court went on to say in Brandenburg, there must be a showing of intent by the speaker. The action must likely result. And the speaker had all of this articulated in his or her mind. I'll say that again quickly before my time is up. The content of the speech has to be such where it's not mere discussion of controversial policies, but the speaker is trying to get the audience to imminently, it could be now, it could be soon, to imminently engage in unlawful action. We're so angry at what we're hearing, we're going to break the law in some way. That's the first criterion in Brandenburg. Beyond that, the court said that the speaker has to have a showing of intent for this to happen. Not by coincidence it happened, but the speaker, as he or she was talking, intended for imminent lawless action to happen. The speaker knew that this would be the likely result, and all of this was articulated in the speaker's mind while the speaker was talking. That is a very high bar to clear. Brandenburg has survived a little over half century. He hasn't been tested much by the Supreme Court. It's still the yardstick, but with former President Trump's speech on January 6th, I mean, millions of people got to see it unfold as this Brandenburg live. And it brought Brandenburg into the 21st century. Did former President Trump reach that threshold that this wasn't just disapproval over the election results, but I'm trying to get my audience to do something about it, and do something about it now as soon, and if necessary, do something unlawful. And I, former President Trump, believe this will be the likely result of my speech, and I intend for this to happen. And that's a very high bar to clear. As was mentioned before, should Brandenburg be revisited? Is it still good law? Should the Supreme Court take it up again? Did former President Trump violate the Brandenburg standards, and how should he be punished? But where does society go from there? It's a lovely ruling, and former President Trump happily or not, brought it into the 21st century. And I'll leave it at there for now. Thank you.
All right. Thank you, Alan. A nice ruling that is now brought into the 21st century. I like that summation. So our next speaker is Dr. Eric Casper, professor of political science and director of the Menard Center for Constitutional Studies at UW-Eau Claire. He too teaches on constitutional law and free speech, and his most recent book is The United States Constitution in Film. Professor Casper, welcome.
Thank you for having me. So where I'm going to kind of take us next is these different parts of the Brandenburg test, with my focus particularly on the question of what it means to be imminent and how we get to that point where speech is protected up to the point where it's imminent. I may touch a little bit on some of those other two elements as well as they come up in some of the relevant cases I'll be talking about. But as we go back to Brandenburg, Brandenburg tells us that the freedom of speech protects even the advocacy of law violation and use of force, unless that advocacy is directing to inciting or producing imminent lawless action and is likely to produce or incite such action. So in particular, that question about imminence, right, that speech is protected unless there is an imminent threat of violence, of law violation. Brandenburg here does reach back to things that were hinted at in earlier court opinions, that were discussed in the opinion of the court, but maybe the court didn't always live up to it, and certainly in some of the key dissents and concurring opinions. In addition to the Judge Leonard Hand decision in the Massa's opinion, where we get the origins of this in another appellate court, not the Supreme Court. We see a number of Supreme Court cases over the years, beginning with Schenck, that we just heard about, where imminence was not really present, right? Go back to Schenck. There you have the Supreme Court upholding a conviction for mailing pamphlets that urged resistance to the draft. There isn't really a threat of imminence, putting something in the mail and something that's received by someone on the other end days or perhaps even weeks later. A follow-up case, the same year of Schenck, 1919, Abrams versus the United States, where the Supreme Court upholds a conviction for distributing leaflets advocating for a general strike. And this is where you start to get some of these famous dissents by, in particular, Justice Holmes, but also some of these opinions by his colleague, Justice Brandeis, where in that Abrams dissent, Justice Holmes talks about how opinions we loathe and believe to be fraught with death have to be protected unless they so imminently threaten immediate interference with the lawful and pressing purposes of the law. Gitlow versus New York, 1925, the Supreme Court upholding a conviction for printing a pamphlet advocating for communism and the overthrow of capitalism. Again, more printed material, and Holmes and Brandeis in dissent. Whitney versus California, which we heard about as well here this evening. Supreme Court upholds a conviction for Whitney for being a member of the Communist Party. Although Whitney herself personally opposed the use of violence, it kind of became a guilt by association decision. And here you see a concurring opinion by Justice Brandeis emphasizing that the freedom of speech has to be protected unless the evil is so imminent that it may befall before us an opportunity for full discussion. And then the same thing with Dennis versus the United States, which we heard about as well. Right? Supreme Court upholding convictions for being a member of the Communist Party and conspiring to teach and advocate the overthrow of the government by force. The threat of imminence here, being a member of an organization that's advocating for these ideas or printing a pamphlet, sending it in the mail. These questions about timeliness. Clearly, at least the court majority in these past cases was looking at this very differently than what we get in Brandenburg, where Brandenburg says that the abstract teaching of these ideas is protected. It needs to be, as we heard from Professor Beagle, that preparing a group for violent action and steeling it to such action. And so you have not just that Brandenburg line there about preparing a group for violent action and stealing to action, which actually was Brandenburg was quoting another Supreme Court decision, Noto versus the United States from 1961. But you have, as we progress through the 1960s, the Supreme Court starting to open up protections for the freedom of speech more in a number of contexts, including in a number of cases dealing with civil rights protesters. And, it's perhaps an interesting case, it wasn't an incitement case, but Edwards versus South Carolina in 1963. Supreme Court ruled that the ordering by public officials of peaceful demonstrators holding signs to disperse from the state capitol, protesters who were there to demonstrate against segregation and had signs that had slogans like "down with segregation," that this violated the First Amendment. And that was not handled as an incitement case. But it's interesting because in that case, it involved the prosecution under a breach of the peace law in South Carolina that prohibited a disturbance of the public tranquility by any act or conduct inciting to violence. But clearly there was not an issue of imminence there. There were some other parts of the Brandenburg test that would be developed later in 1969 that would have been a problem as well. But we see, as we progress into the 1960s up before Brandenburg, this push to protect more and more expression. But then after Brandenburg, there's this question of how do we clarify incitement, particularly imminence? There are a couple of key cases that I want to talk about in that regard, and then maybe one or two other cases that I'll touch on that get to kind of some of these bigger, broader questions about the concept of the freedom of speech that the court wanted to protect in Brandenburg. One of the cases on imminence is Hess versus Indiana. There was a disorderly conduct conviction here for Hess. It involved, the situation here involved police clearing a street of around 100 or 150 anti-Vietnam War protesters at Indiana University. Hess was one of these protesters. As he's being cleared out of the street by the police, he uses a particular choice word saying, we'll take the effing street again, or it's not clear if he actually said again or later, but he has this kind of bold proclamation to the police officer, we're going to take this street again, we're going to take this street later. And he gets arrested and convicted of disorderly conduct. Supreme Court, when hearing his appeal, says that at best, that statement by Hess could be taken as counsel for present moderation. Or at worst, if it really were asking a question about is this incitement, Supreme Court said his statement amounted to nothing more than advocacy of illegal action at some indefinite future time, and that's not sufficient to permit the state to punish his speech. And so kind of a couple of things there in Hess that are noteworthy. One is it goes to this question of imminence, right? Saying that, we're going to engage in this illegal activity in the future wasn't enough for it to be imminent. It also goes to how language can be misinterpreted. And that's something I'll talk about again here a little bit later, but this question of how language itself, we have to be careful that, if we take language literally, that may not be the intent of the speaker for it to be understood literally. That concept was illustrated as well in a case called NAACP versus Claiborne Hardware. The Claiborne Hardware decision was issued by the Supreme Court in 1982, but it actually took a very long time to get a final resolution in that case because the situation in Claiborne Hardware began in 1966. The relevant facts go back to 1966. You had African-American citizens in Claiborne County, Mississippi, who presented to the elected officials, who at the time were all white, a list of demands to try to promote racial equality and integration. After the demands weren't met, the NAACP engages in a boycott of the white-owned businesses in Claiborne County. And there were store watchers who were dispatched to watch who may be frequenting those businesses. Now, the key individual in all of this was a person named Charles Evers, who was a field secretary of the NAACP in Mississippi. And some of the statements that he made, as it was laid out in the Supreme Court opinion in Claiborne Hardware, the Supreme Court said that Evers stated that boycott violators, in other words, people who broke the boycott and frequented these businesses, would be quote unquote disciplined. And one of the things that Evers was alleged to have stated is that the sheriff can't sleep with boycott violators at night. There's another speech where apparently, at least according to the US Supreme Court, he said, if we catch any of you going in any of those racist stores, we're going to break your damn neck. And in fact, at some point later on, though some people who broke the boycott had their property vandalized and were physically assaulted. Now, eventually, this case gets to the Supreme Court, and the Supreme Court says that supporting a boycott in and of itself is certainly protected expression, certainly a protected First Amendment activity. And the court also went on to say that speech does not lose its protected character simply because it may embarrass others or coerce them into action. Now, the court was also clear that the First Amendment does not protect violence. But in this case, the court said any relevant violence happened weeks or months after the speeches took place. And so the court in Claiborne Hardware really focused on this question of imminence, and that there has to be this connection in time between the expression advocating for this type of activity and the activity to occur. And in this case, the court said, look, it wasn't within a reasonable enough period. And in particular, the court focused on the ability to use language to rally a crowd. And the court talks in Claiborne Hardware about that the emotionally charged rhetoric of Evers's speeches did not go to the point where it was unprotected under Brandenburg. Because the court said, not only is there this question of imminence, but the court says that strong and effective extemporaneous rhetoric cannot be nicely channeled into purely dulcet phrases. That an advocate must be free to stimulate his audience with spontaneous and emotional appeals. And so, again, that goes to not only the question in Claiborne Hardware of imminence, that the violence didn't happen or the illegal activity didn't happen right away, but also that speakers sometimes will speak in phrases that are not to be taken literally. And so the Supreme Court, again, gives a pretty wide berth when it's asked to follow up and clarify some of what it laid out in this relatively short test that we heard here this evening from Brandenburg versus Ohio. Now, there is kind of one other significant case that in and of itself was not an incitement case, but I think it helps to clarify what the court meant in some of these cases following Brandenburg that were incitement cases. And that was a case called Watts versus the United States. Watts versus the United States involved the Supreme Court overturning a conviction for violating federal law banning threats against the president. And in Watts, what Watts did, Watts was a draft age man. This is during the Vietnam War era. He said in the presence of an Army investigator that he would not submit to being drafted. And instead, he insisted the following. He said, if he's drafted, he said, I am not going. If they ever make me carry a rifle, the first man I want to get in my sights is LBJ. And this is what he was convicted for as far as threatening the life of the President Johnson. But the Supreme Court overturns this conviction, talking about how what was being engaged in here was a form of political hyperbole. And that the political hyperbole is protected expression as the language of the political arena is often, the court says, vituperative, abusive, and inexact, right? Getting to that very similar point in the Claiborne Hardware decision, right? That sometimes people if they are, giving a very passionate speech, they might say things, and they might say things in the moment that, are not to be taken literally, or that maybe go beyond what they plan to say, or maybe they say something that they quickly regret. And the court says, under the First Amendment, we have to give the speakers the ability to engage in that. Otherwise, you can have this threat of a chilling effect on expression. In this case, then, what the court said in this Watts decision, that Watts's only offense here was a kind of very crude offensive method of stating a political opposition to the president. The court says, taking it in context and regarding the expressly conditional nature of the statement and the reaction of the listeners, we do not see how it could be interpreted otherwise. And so, again, some of these follow-up cases that come in either in this case, the Watts decision the same year as Brandenburg, or some of these cases that come up within the next few years or within about a decade of Brandenburg, help to clarify some of these parts of the test and help to show us this question of imminence, as well as how you have to kind of take the speech itself within the context of what's going on overall. It's not just the words, but it's the context of what else is happening. And that's probably the best place to turn it over here to Professor Sweeney.
All right. Thinking about context, I can't wait to hear how we do context in the context-free internet age. But first, batting cleanup on tonight's panel is Dr. Joanne Sweeney, professor of law at the Louis Brandeis School of Law, University of Louisville. Her scholarly work addresses freedom of expression, feminist jurisprudence, and comparative constitutional law, most recently focused on the United Kingdom's Human Rights Act and the European Convention on Human Rights. Professor Sweeney, welcome.
Thank you. I'm going to actually use slides because I am going to, my part of this panel is going to be kind of dragging us into the 21st century, and I want to talk about the events of the last few years with a focus on Donald Trump and the many potential and actually litigated claims of incitement that he has been involved in. So I'm going to share my screen, hopefully. Let's see. Let's see. It is, that's interesting. It's not giving me the option for it. So hang on one second. Oh yes, it's probably way down here. I have too many tabs open, everyone. Let's share the screen. Okay, so let's see. How do I start my slideshow? There we go. Start slideshow from the beginning. Here we go. All right, there we go. So I have a few images. Some of them are Trump's tweets. Some are some other, just kind of giving you the picture. And what this first slide does is it shows you the one on the right is the January 6th attempted coup. And the one on the left is where I'm going to start my story, which is at a rally in Louisville, Kentucky on March 1st, 2016. And that is actually, that case is what brought my interest, started my interest in incitement generally. So what I'll say is that, you know, Brandenburg, as Professor Beagle and Professor Casper were very neatly talked about, is that a lot of the earlier cases, and you can go all the way back to the World War I cases, incitement seems to show up during times of unrest in the country. So Brandenburg was during the civil rights movement and, you know, the backlash to it. And then, so what we find ourselves in, you know, the late 20th century, like late 2010s and then 2020s, is another time in this country when there is a lot of unrest. There's been a lot of resurgence of anti-Muslim, racist acts of violence and vandalism. A lot of this movement was started by the proposed and then sometimes actual removal of Confederate flags and statues from public buildings. And then a lot of people have pointed out that a lot of this you know, division in the country and the unrest and the protests and violence have been spurred on by the rhetoric from Donald Trump, both before he was president and during and even after. So these incitement claims have come around based on Trump's words, and the January 6th, that there's been just, people have been going on and on in the news about Trump being has incited the crowd, which is partly what we're here to talk about today, is was that actually incitement? But I want to take us a little further back to a prior incitement lawsuit, as I hinted at, from 2016. And this case is called Wanguma versus Trump. And so what happened in this rally on March 1st in Louisville, Kentucky, is Trump was giving a speech. And again, this is before he was elected. and the crowd, there were some protesters in the crowd wearing signs. They were actually silent. They weren't saying anything, but they were standing there with signs inside the venue, and Trump saw the signs, and some of the crowd did too, and were getting agitated, and Trump shouted, "Get him out of here," and the crowd started pushing the protesters out, and actually got into physical altercations, hit them, pushed them, etc. And so the words that became part of this lawsuit was "get him out of there." But I do have to say, because the Sixth Circuit certainly noticed, that he also said, "Oh, don't hurt him," as they were being shoved out of the building. He also said, "Don't hurt him." So this picture is actually of the plaintiffs in this case. And the lawyer behind Ms. Wanguma is my friend Dan Cannon, who got me started on this path, because he said, "Hey, you should write about incitement." And I said, "I don't want to." And then he said, "But if you do, I might be able to include your law review article in a brief to the Supreme Court." And apparently I can be bought. So that's where we started. And so what happened in the Sixth Circuit, it came down to what is a call to action. And Professor Casper was talking about these elements in Brandenburg, and Professor Beagle as well. And so what we focus on from Brandenburg is you can't just, advocate and say, yeah, that would be really nice if somebody, beat up these protesters. And a lot of, for example, Hess and these earlier cases came down to this kind of conditional language. If you do this, I will do this, kind of language, which the court has repeatedly held is not imminent and not a call to action, because it's conditional language. It's not saying do this, it's saying if this happens, then do this. And this is, when we talk about incitement, there's two major kinds. There's direct incitement and indirect incitement. And direct incitement is what we traditionally think of as an incitement, which is basically someone saying, kill that guy. Which is a command. It's a call to action. It's telling someone to do it. And the definition is basically getting someone to engage in violence or an illegal act when they wouldn't have done it otherwise. So there's, it could be very specific instructions, but you can't be just general instructions like, we should get, we should fight back. Arguably, we're going to get there, because then we have indirect incitement, and that is something that is much less discussed in the cases, and certainly wasn't discussed by the Supreme Court. This idea that it doesn't have to be a direct call to action on its face, that you can use the words and the context around the words, as well as whether the audience of the speaker would understand them to mean something specific. You can use coded language. For example, like in solicitation to commit a crime, you can say, like, it'd be really nice if that guy wasn't here tomorrow. And that's, that sounds like, yeah, I guess that would be nice. But what it is in context, if it's me saying that about, someone that cut me off in traffic, that's probably not incitement. If it's, a mob boss saying it to their hitman, that may be incitement, because it means something different to those people. And the picture I have here is a very famous example of indirect incitement from Henry II, which was, "Will nobody rid me of this meddlesome priest?" which basically means, I want you to kill that guy, kill the Cardinal of Canterbury, Archbishop of Canterbury. Yeah. Anyway, so this is what we're going to go. Now we had the Wanguma case. Ultimately, the Sixth Circuit found it was not incitement because they focused on the words of that, get them out of here, and how vague that was. He didn't say actually hurt them. In fact, he did say don't hurt them. So clearly, despite the context of what was going on at the time, despite the fact that there had been violence in other rallies, that Trump had used those words before, get them out of here, that Trump had gone on the news, Fox News, if you count that, that he had spoken positively of violent protesters, of violent audience members in the past, but that was not counted. And so indirect incitement, for what it was worth, took a hit. So now we're moved on and we're in 2020. So this is, oh, and by the way, my friend never actually filed with the Supreme Court and did not cite my law review article to the brief. So I was lied to. I just want to point that out. And now it's being recorded. So that's important for me personally. Okay, so let's move on to January 6th. We'll go to 2020, but we need to take one step back. As a dress rehearsal for January 6th, we have this kind of sequence of events that happened with regard to the Michigan governor. So on March 27th in 2020, Trump was criticizing the Michigan governor, and this was because of the mask mandate and because she was very critical of Trump as well. And so he started criticizing her. The next month, he had just tweeted "Liberate Michigan." He tweeted "Liberate" a bunch of places, but Michigan was one of them. And then on the end of that month, there was an armed protest that stormed the Capitol, and they had plans. They had actual plans to kidnap the governor in response to this mask mandate. And then in response to this, Trump tweeted, support in a way of these protesters by saying that, that the governor of Michigan should, meet them part way, and that they're very good people, and they just want their lives back. And he told her to make a deal with the people that tried to kidnap and maybe harm her. So this was what happened, an earlier, very quick run through of what's going to happen for January 6th. So we're setting the stage now for January 6th, and this is the 2020 presidential election. And we start, and he has a bunch of hashtags. One of them is Stop the Steal. Another one is Rigged Election. So before the election day, so back in November, we go back to June and July. He's already setting the stage for arguing that this election was rigged, that mail-in ballots are going to be meddled with, and the election is corrupt, because arguably he saw the way the polls were going and knew that based on his statements that his voters should go in person, that more votes against him would be mail-in than the other way. So he's already setting the stage by arguing that this election, before it even happened, was rigged. And then we have Act 1 of this play, which is November and on election day and just before, right? Because we had mail-in ballots, and because the in-person ballots came in first, so he was able to create this narrative that he was winning, and then get angry when the mail-in ballots started getting counted and his numbers started to slip, and then it started to become clear that Biden was going to win the election. So again, he's still arguing this is rigged, a rigged election. And then after November, leading up between November and January 6th, we have a series of tweets, and I took like the greatest hits. This is certainly not everything. That he was tweeting things like, again, saying that this was a travesty, it was a rigged election. He's, talking about this January 6th protest and rally he's going to have in DC, and telling everyone you should be there. And January 6th was an important day because that was the day that they were supposed to certify the election results. It was already in at this point. Biden had been declared, but until the Congress had officially certified the results, which is usually not even worth like reporting on the news because it's just so obvious, but it became a real point of contention. And so he was going to have a rally on that very day nearby, near the Capitol. And so, and the last tweet I have here is that he's calling out the Democrats and Rhino, Republican Party. Rhino stands for Republican in name only. So he's calling people out. And he's hinting at and he's speaking positively of all the protesters that he asked to come are coming, and they're pouring into DC. And he says they won't stand for a landslide election victory to be stolen. So again, he's saying not only did he win, but he won in a landslide, and he's speaking positively and warning that his supporters are not going to stand for this rigged election. And then we have January 6th itself. Here's a lovely picture of this speech that he gave. And the speech itself had a lot of language in it that arguably could have been incitement, including "Fight Like Hell," which is, hey, the name of this very panel. And then things like, we're going to walk down Pennsylvania Avenue, we're going to the Capitol. And then, this again, we're going to give our Republicans the kind of pride and boldness that they need to take back our country. And so that's the speech itself. He also tweeted a few things that were super relevant. One, which was when the riot was going on, he talked about how Mike Pence didn't have the courage to do what he needed to do, and that the USA demands the truth. And then finally, after the riot, he still talked about how, it wasn't the protesters' fault. He still defends them and says that this was because of, because the election was rigged. He's still not conceding that he lost. And he's defending these people that stormed the Capitol and injured the police. and killed, people died that day, he's still defending them and saying that, you know, even though he says go home with love and peace, this again is after the riot has already started, and he's still defending them and speaking positively of these people. So what happens here is that if you just take Trump's words out of context, if you just look at the words like, we're going to fight like hell, that sounds a lot like what happened in Claiborne Hardware. They're like, hey, they're just speaking in this really, my favorite word, Professor Casper mentioned, vituperative language. And it's just, he's just giving us fiery speech. It doesn't mean anything. But if you look at the context of it, if you look at what happened back in 2016, if you look at what happened in Michigan, it starts to take on a different image, because it's not just his words, it's how they're understood by his audience. And that has to be based on what has happened in the past and what they think he wants. And then we get into intent. What did he actually want? That becomes a question. But if we're just looking at whether these words, fight like hell, and we're going to walk down Pennsylvania Avenue, if that is incitement legally, we have to think about how much context are we going to let in and where, if we're going to understand what he really meant and what he really wanted, and whether there was an understanding between him and his followers that were there. And if you ask them, they said they did it because he told them to. And that was actually true back in the 2016 case, that they said, we only, beat up these protesters because that's what Trump wanted us to do. So they think, and this could be that they're trying to defend themselves in litigation, but they seem to think that he was telling them to act that way. And so the question that we need to figure out, if we're going to re-examine Brandenburg, if we're going to put more context in, what context are we going to include? Are we going to use it to understand the speaker's intent and what their words actually meant? And even, can we use it to understand imminence? And this is particularly important for people like Trump, who have done this repeatedly, and we have more context to look at. And so that's where I'll end, is that with a whole bunch of questions, it is unclear what is going to happen, if any cases will even be brought for this latest coup attempt and this violence that people are saying in the media Trump incited. But whether he meets the legal definition, I think, is still very much up in the air. And I think it is a very good time for us to examine what we want incitement to mean and what we want to include when we are trying to determine whether incitement has happened. And I'll finish there.
All right. Well, we have a lot of questions. We have questions that have been coming in from the audience. And so I just want to encourage you all once again, if you have some questions you'd like to see addressed by our panel, please do write those into the question and answer box. When you see that it is checked off as if resolved, it doesn't mean necessarily that a speaker has addressed it. It does mean that one of our student staff has recorded it and is contributing that to a set of questions that they're putting together. So next, I'd like to invite our panelists, all of you, to turn your cameras and your microphones back on. And I wonder where you disagree with each other and what questions you might want to ask each other. So this is kind of a free-for-all, and I invite whoever would like to go first, whoever's on the edge of their seat ready to protest something another has said, to jump in and speak.
I'm going to say not me, because I just finished.
I'm trying to get my picture again.
It's in the bottom left.
Yeah, what am I missing there? The start video, the mute? Oh, there we
you
go.
are.
Oh, you're brilliant. Oh, thank you, Joanne. Oh. I'm sorry, was the question, does it have to be a group discussion first?
No, this is just your opportunity to speak to each other a little bit and ask questions of each other, or offer rebuttals, and then we'll go to some audience questions. So this is just your time as panelists first.
Oh, I can change the direction of this very easily, and I'm too tempted, because Justice Hugo Black is my idol. And he was the only one on the Supreme Court. Even Justice Douglas didn't go that far. You know it's coming, Eric, I think. He said, clear and present danger is legislating from the bench. It is too subjective. And the degree of free speech citizens have should not depend on the subjective whims of justices from one case to the next. Not even as close as Alloy, Justice Douglas went quite that far. And I think I'm right if I say Black was the only one who per se rejected clear and present danger. Maybe that'll come up. What is the court's role in this? Is it legislating from the bench, Eric? You want to start?
Well, I mean, Justice Black, of course, being the textualist that he was on these types of questions, I mean, he went back to the language of the First Amendment. Right? Congress shall make no law abridging the freedom of speech, and he said no law means no law. So, you know, his position on that, although it wasn't necessarily always consistent. I mean, there are examples where, you know, he would have, and he did find expression to be something that could be punished. But, you know, in all of these cases involving questions of incitement, and particularly these incitement questions as they come to the Supreme Court before Brandenburg, cases in, you know, the 1950s, for instance, he's outraged at what his colleagues are doing. And I think that definitely brought something to the Supreme Court in terms of focusing on the idea that, you know, the freedom of speech really was being devalued in his mind during that period. Now, of course, I think, as you point out, there's no other justice. There was no justice at the time, and there's been no justice since, who takes that literal absolutist approach to what the First Amendment protects in this context. But it does, in some ways, I think, help the court come along to what it did in Brandenburg. And, you know, Brandenburg might have looked differently if we didn't have Black and along with Douglas rallying to that cause all those years, who themselves, of course, were following in the footsteps of the great dissenters of Holmes and Brandeis on these questions.
May I interject one more quick thing? Number one, Black always said the answer is more speech. And to have more speech, it might be necessary to restrain the crowd to let the speaker finish. Run with that one as you wish.
Well, I think that gets into kind of the imminence part of incitement, because I think that's a big piece of it, is that if the cure for bad speech is more speech, incitement disrupts it because people act before the good speech can come in and correct it. And so what we're seeing in the 21st century, and this is, you know, there's also an incitement case that I've looked at that with the Unite the Right rally in Charlottesville, that the problem is that more speech isn't coming in, the good speech isn't coming in, because people are purposefully blocking it out. And that is because the listeners are, you know, because with social media, you are able to do that. You can create bubbles for yourself. And so if there is no opportunity for good speech to come in, then what is the solution? It can't be more speech. There is going to be no more speech. So should we be looking at that as some kind of piece of incitement, is to kind of transform imminence as less of an issue of timeliness, but rather an issue of whether people have time to reflect, have the ability to reflect, not just the time, but whether they are able to sit back and go, like, maybe I shouldn't kill that person. So is that would be something that I would say would be a big part of it, especially in the 21st century, when you see a lot of the speeches I showed. You know, Trump is unique because most of the cases that come up in the 21st century are not someone literally speaking physically in front of a crowd with this immediate reaction to it. Most people don't do that. The more recent incitement cases that have gone anywhere are ones like on websites and you know, using social media, where it's less clear when the person speaks. They type it and they put it up. When does the audience receive that message? It's not simultaneous. So then we have an imminence issue, back to, you know, clear and present danger with pamphlets. Like, you know, tweets are like the modern version of a pamphlet. We don't know when someone's going to receive it. And so if we're going to update incitement, especially to include this kind of these new technologies, we need to probably rethink what imminence means and why that requirement exists. And it can't just be like, oh, because, you know, it has to happen fast. Like, why does it have to happen fast? And can that be accomplished through these bubbles and through these, you know, purposeful, like in Charlottesville, the different boards, message boards and apps that they use, they deliberately kicked out anyone who dissented. And is that something that we should be considering when we're looking at imminence for incitement?
Mhm.
If I could ask a question of you all, when you reconsider imminence, do you have to also reconsider intentionality? And I think about the way, and this is a different sort of free speech question, but the way the Charlie Hebdo speech was received in North Africa compared to how it was received in Paris. And that it triggered a reaction in a faraway place that people did not recognize or foresee. They did not anticipate. But people looked at it and said, you should have thought of that. You should have seen this coming. And, you know, does that mean we have to think about intentionality as longer range? You know, Joanne, you were talking about the crowd at the Capitol reading Trump's tweets. What about the ones at the state capitals who were anticipating action maybe later in the day, or maybe later in the month, or maybe even this month?
I think, isn't March 4th another date that they've
We're not
indicated?
supposed to say that, yeah, but yeah, go.
Sorry,
No,
what?
No, I'm kidding.
Is that
I'm
secret?
kidding. You're right that there is another date. So again, thinking about intentionality as long range, thinking about imminence as potentially long range, what do those categories mean in this age of social media that is reshared and recontextualized?
I'm happy to talk again, guys.
I agree with what you said, Robert. I agree with you 1,000,000%. How about the size of the audience in the internet age? It's no longer who happens to be in the area and listened to the speaker. Now, other than the dictatorships, the whole world is at your fingertips, right? You're bound to get someone with 100 million people who will get ideas, whereas a crowd of 20 and facing a speaker in person won't. So how might the internet affect the Brandenburg relevance in today's times?
Yeah, well, I mean, but that's always been part of the issue, right? Or at least as long as the Supreme Court has been using these tests for about a century or so, right? I mean, Schenck, I'm not sure if it was fully carried out, but the plan was to mail 15,000 pamphlets. And so, I mean, they were looking to reach a broader audience, perhaps in a variety of places. Now, again, the internet gives you global reach potentially. But I mean, that's always been part of the equation since the Supreme Court has started using these tests, and that's, you know, that would be my concern with altering Brandenburg, because I mean, in some ways that takes us back to what we saw in some of those earlier cases, which scares me, right? I mean, people who are advocating for something that gets misinterpreted and then they wind up in prison, and so that I think there's that aspect to it. I think that, I mean, there is something about, at least in these Supreme Court cases, some of these big ones like, you know, Brandenburg or Claiborne Hardware, where the court does seem to at least imply that when you're talking about incitement to a crowd of people, I mean, there's a unique type of threat of a crowd becoming the mob. And although individuals could be, you know, they could see something online or they could be spurred onto action, I mean, I think there is, it's a different type of threat. And I think it's less of a threat in terms of these types of questions than the mob that gets whipped up into a frenzy. And again, if it is the case that we're saying, you know, the internet can incite people, or they can be incited online, you know, then there's also a danger there about, you know, what about, you know, if someone pulls a book off the shelf at the library, you know, and it's the Communist Manifesto, and they read that and they're like, okay, I'm going to go and take action. You know, I mean, we're going to start banning books that have that type of call to action. And so I think we'd have to be very careful in terms of what we do here Of course, none of us are doing it, but whatever the Supreme Court does here in the future, if they do, change what Brandenburg requires.
Yeah, and I think that the intent, I think that makes a lot of sense. I do think that the intent requirement requires to be something of a meeting of the minds, that the speaker, if someone misconstrues what the speaker says, I don't think Brandenburg calls that incitement. And I think that the question then becomes, how do you figure out what the speaker intended by their speech? And, if we're going to use the Trump example, it's not really much of a mystery. There's certainly a lot of people that reported that how excited he was about the coup, except for the attempted coup, except he thought that that he didn't like how low class the people looked that were storming the Capitol. That's why I included that tweet afterwards, where he's kind of defending them. And it took him quite some time to do so after he gave that speech, which I didn't quote, but it was just, like, we love you, you're very special, right? When he said that in his speech, I think that evidence of how they react after the fact could be used to show intent and whether they wanted this violence to result. So I do think that intent needs to be there, because I agree that especially as we go global and people have different contexts, right, of different words mean different things. And especially if now we're going to put things through Google Translate, now we got bigger problems. So I do think that there needs to be some evidence that the speaker intended this to result, whatever lawless action happened afterwards. So I do think intent can kind of take on a lot of those issues you identified.
Oh, yes, very much so. Suppose a speaker begins with no intent, but the momentum of the audience catapults the speaker into that mindset.
Yeah. I mean, there's stuff, that's what's so interesting about the in-person stuff, is that you really get a sense that the energy gets, they feed off each other, the two different sides.
Oh, yeah.
Yeah, Robert, I'm sorry, because I think you thought we were all going to disagree with each other, but when we talked earlier, we really all agree pretty
that's
much.
fine. That makes a maybe a more consistent reading of the law, which is always nice. So we do have a lot of questions that have been coming in through our Q&A, and I just want to remind those of you in the audience that if you do have a question for us, the question and answer section is ideal for that. And our student panelists are about to join us with some of your questions. And so I want to welcome Kara Orbell. Kara is a third-year student, a staff member at the Norman Miller Center. She's an international business and Spanish double major. And also want to welcome Bethany Kreklow. Bethany is a first-year staff member with us, first-year student in history education, which, well, we got some history education here tonight from everybody. So I think one of their questions was that had been submitted was, again, dealing with President Trump and the impeachment, and thinking about, now this was a political trial. Is he still vulnerable to a different sort of trial, a civil or criminal trial? And what are your thoughts in that regard with regard to incitement? But I shouldn't have said all that first. I invite you, Kara and Bethany, to speak up. Kara, go ahead.
Okay, so I am going to ask a question that Bob just referred to, but the question was relative to the events of January 6th. Could former President Trump be indicted within the U.S. criminal justice system relative to the events of January 6th? If so, what entity would have standing to seek this? Is this a remote possibility?
I think yes. I think what the crime would be conspiracy to commit sedition is an obvious choice for what. So here's the thing that's interesting about incitement. Incitement is both a crime and a way to get past the First Amendment. So it's two things. So when we talk about incitement, it can be really complicated because which one are we talking about? And they kind of have the same definition, but they can be used two different ways. So incitement is a crime. In the 2016 case I mentioned in Kentucky, he was sued under civilly under an incitement to riot statute in Kentucky. So there are laws that make incitement illegal. I believe incitement's a federal crime. So theoretically, he could be brought by the Attorney General, I guess. The U.S. Attorney actually would be bringing that case. So he could be sued civilly, probably, but definitely criminally. And now that he is no longer president, you don't need to impeach him. He is just a regular person. And so he can, that's what the impeachment would do, is it would make it, generally, you can't be convicted of a crime until you get impeached first. That's why impeachment was necessary. And then the question is, why did they do it after he was no longer in office? Because they wanted to use it to prevent him from running for office again. And also because they wanted to show that there was some, consequence for what they perceived him as being part of that coup. You guys may disagree, but that was my opinion, that I think it's wide open.
I agree with you, Joanne. You put it very well.
Yeah, I think there's definitely a possibility, right? And the Constitution talks about how whatever happens in an impeachment trial doesn't preclude civil or criminal liability. And I mean, we've heard a lot this evening about some of the evidence that could potentially be there in a civil or criminal trial. There's a side for the defense as well, if that comes up, right? You're talking about, you look at the speech. I mean, there's a lot of hyperbole, which we know from Brandenburg is protected. There's a lot of criticism of government officials, which we know Brandenburg and follow-up cases say are things that are protected. There's definitely a lot of language that doesn't tend itself to incitement. There were many people there who, of course, did not break the law, right? A lot of people, thousands and thousands of people who did not go inside the Capitol, for instance. And there's a real question, and this is an interesting thing, and going back to this question of the meeting of the minds, because of the diversity of that size of crowd, and the fact that you have some, at that crowd, some real hardcore conspiracy theorists who may take things differently than a lot of other people would. And how much do you, how much do you think that affects the outcome? I mean, there's an argument there for a prosecution or for a plaintiff in a civil suit that, they're, knowing that those people are in the crowd and they'll look for any signal to be, the thing that spurs them to action. But of course, the defense argument, being that, well, how would we know how they would react? It's not the intent of the speaker to do that. And it's a real question that you could raise in that type of case. Was the intent here to send people to commit violence or to cause a big newsworthy spectacle, to get a large crowd around the Capitol? And then finally, I guess there would be these questions about the timing. On the one hand, some of these material events are occurring at the Capitol when the president is just starting to speak at the ellipse, or when he is speaking. And so there are people who aren't there present, but that goes back to that internet question, right? If people were at the Capitol live streaming the speech, and then they took that as the signal to go forward, you got to kind of work that out. And so if a case does get into court on this, the timing of that and what people actually did and when is going to be, and it's going to go a long way in what the outcome of any of those cases would be.
And I don't know if the term dog whistle is a legal term, but it will certainly come up in that kind of conversation, won't it? And, when we think about the possibility of Trump being charged with something, we do know about him that he will appeal. So if the court is to reconsider Brandenburg and amend it, maybe this would be the moment. Bethany, I think you had a question.
Yes, I do. I actually have two questions. They're both related. They're about social media. So the first one is, when it comes to censorship online and through social media, like, for example, Twitter, Facebook, Parler, how far is too far? And how can we measure when to start or stop without taking away the rights from citizens who have opposing viewpoints?
So the first thing that's a really good question. And I know a lot of people are screaming censorship and First Amendment, especially because Trump got kicked off Twitter. But that was Twitter's decision. It was not a government decision to censor anybody. And so because it wasn't the government doing it, the First Amendment is absolutely not implicated. So Twitter, as a private entity, organization, business, whatever, can kick people off. Parler can kick people off, Facebook can kick people off, and there's no First Amendment recourse because the First Amendment applies only to government actions, initially only Congress, as it says, but then through the 14th Amendment, it can also apply to state governments as well. So, you know, if we're going to ask, you know, what, you know, kind of a policy wise, how far do we want it to go? That's fine, but it's not about the First Amendment anymore because it's not the government.
But Bethany, you're right. Where do you draw the line? You see it frequently on college campuses. They either disinvite conservative speakers. And it's not necessarily because what they'll say in their speech that day, but because of the reputation they have. So does Brandenburg hinge on a cumulative person's reputation in the aggregate? I'm known for being reactionary with the Interstate Commerce Clause, for example, on, yeah, I am. I go back to the pre-1937 in a heartbeat. Now, that's just an opinion.
I think flashbacks from law school. I'm sorry.
Oh, I'm not insulted. I'm not at all. Not at all. But what do you derive from that? We shouldn't invite Dr. Beagle to be a speaker because he's reactionary on the Interstate Commerce Clause. And I'm an isolationist, frankly. So we shouldn't invite him for that. How far do you draw the line? In other words, is the incitement part based on what the person says that day, or is it a reputation he or she carries over years? Is incitement cumulative?
I should say, Alan, we didn't know that about you before.
Oh, my students do.
You need to vet your speakers better.
Yeah, apparently so.
Hey, that's a question. Yeah, you disinvite me in the future because you don't like my constitutional views. I'm a textualist diehard, and you didn't invite me for that reason.
If you wanted a fight between me and Alan.
If I could rein in and go back to Bethany, you said you had a second part. Go right ahead, Bethany.
Yes, I do. Okay. Continuing on the social media with like incitement and like what is considered and what isn't, with the vast amounts of information available through the media, how do we decipher what is fact and what is fiction?
It's in the eye of the beholder after all is said and done.
Disagree. I think there's truth. I think truth still exists. But I think that it's harder to find, and there was an article posted that like kind of showed different media outlets on like an axis, kind of like, it's not just whether they're liberal or conservative, but how important is fact checking for these different organizations, or are they more propaganda? Like we get in between pure news, just pure fact, and propaganda, and most news outlets kind of go in between. It's impossible to report on anything without, you know, your own personal views kind of like leaking in even a little bit. But so what I would suggest is, you know, I hate this whole fake news thing and this attack, because I think it is attack on the First Amendment itself, because it's censoring the media by just making people not believe anybody. Wait, you want to pause? I'll pause.
No, I'm sorry. That was a note to Kara. I'm sorry.
So what I would say is, to answer that question as best I can, is that I would look for multiple sources at the very least, and also investigate the source itself. Is it a reliable source? Some websites, you know, are, you know, what's been great about social media and you know, this idea that people can kind of, you know, it's democratized the spreading of information. But what it does is it makes it, there's no fact checkers if I just blog about something. So you have to be very vigilant on checking when you read something. If it sounds crazy, like, oh my God, I can't believe, you know, there's this pizza place that's engaged in, you know, human trafficking, sex ring for children, like, then maybe you shouldn't believe it and you should look for it in other sites. So especially, you know, the memes that get posted everywhere, that is not facts. That's just somebody just putting some words on an image. So, you know, one of the things I still use a lot is Snopes. And I've actually gotten to Facebook arguments with people who say Snopes has a liberal bias, which is just, I don't even know where to go from there.
Yeah, I think, you know, it comes down to, you know, we need to be doing a better job of teaching media literacy. Certainly that has to be a better part of what we do in terms of education. Because I mean, we do have, of course, a whole line, and this could be a completely separate panel, but a whole line of cases the Supreme Court talking about how in various contexts, saying things that aren't true, that has First Amendment protection, whether it's, for the purposes of, it's inevitable that in discussions that people might say things that are untrue, to the use of humor to give us, parody and satire, that, and I don't see the US Supreme Court going in a different direction on that. And I think if they did, that would put us in a dangerous place for other reasons. So I think it does come back to some of that same advice, in terms of looking at the sources and confirming multiple one, and then we need to do a better job of teaching that at the high school level and the college level, certainly.
On a humorous note, is there a modern equivalent of falsely shouting fire in a crowded theater? People don't go to physical movies much anymore.
Well,
Is there a 21st century equivalent to that?
so like a flash mob?
Yeah, I don't know. Falsely shouting fire in a crowded theater. People don't go to movies that much physically.
Well, no one's going to movies right now.
So what's the 21st century equivalent of falsely shouting fire?
Well, and this is one I was going to ask Eric, actually, because he's written a book about the Constitution in film. And I was thinking, oh, now it's the Constitution in film, but also in movie theaters when we're talking about incitement. But we'll not go that direction at the moment. Carrie, you were ready with one, I think.
Yeah, the next question has to do with the language that Trump was using. So Trump used the verb fight and hell, but he also used you a lot. And so this question refers to whether you was referring to those in the crowd or you was referring to just an impersonal use. And so how does this use in the context of impersonal versus referring to the crowd impact the degree of the incitement?
I think he was referring to the crowd in front of him. When you look at the larger context, he appeared on that day. It didn't have to be January 6th. It had more potency that day, but it didn't have to be then. You look at the tone of his rhetoric, how the speech is getting more accelerated as the crowd is chanting, and he knows that's his base. He didn't just meet them that day. I think he was directing it to that crowd. And I think he had in mind storming the Capitol. I always feel that way.
I think if you look at the prior protests too, the rally, if you go back to 2016, he's used to people being violent in the crowd when he tells them to.
Yeah.
He uses it, he likes it. And so I don't think I think he could have been doing both. I think he could have, there's no reason why he couldn't have had a single intent. He could have been trying to create sound bites and, get a good media coverage and saying you to everybody, but still also be directly talking to the crowd in front of him. And, he certainly was, like he brought documents, like he was showing them things. So he was certainly also talking to that crowd. So I think, again, this is where context comes in. If you think about what has happened in his prior rallies, he knows full well that violence could erupt if he tells it to, and he knows he'll get away with it too. So
he had the whole Brandenburg criteria articulated. Right from when he woke up that morning, I will always feel that way. He met the Brandenburg criteria squarely. He's a role model for Brandenburg. I hate to put it that way.
Him and Clarence.
Well, it was certainly highlighted in the articles of impeachment, or the article of impeachment. The language of Brandenburg was just all over that, and that is what they sought to prove. Mm-hmm. It sounds like all of you think that they did successfully prove that, the House managers. I'm hearing it from Alan and Joanne. Eric, I haven't heard that from you. Can I put you on the spot?
Right. Well, I think that what's at issue in the impeachment trial is a little bit different than what you would look at in a civil or a criminal case. Because there's also the question of the oath of office that one has. I mean, and whether or not that was carried out through the events of the day. There's a significant amount of protected expression that can also be the basis for an impeachment. To take us away from the events of January 6th. If a president decided to march down Pennsylvania Avenue to the Capitol and, burned the American flag there, or if the president, burned a cross on the White House lawn. If the president was, and I'm not speaking of any president, it's a hypothetical president. If a president were, making pornographic videos at night and putting those online, right? These would all be things that in different contexts would be protected by the First Amendment. But if the president of the United States did these things, that certainly would be grounds to open up an impeachment inquiry. Or the president, advocating that a foreign country should come to the U.S. and invade us, right? And so I think it's a different set of questions that we might have for an impeachment versus if this becomes a criminal or a civil case.
Yeah, does the president get held up to higher standards with Brandenburg because of his earnest station in life? The court never addressed that. I think yes, but that's neither here nor there.
Well, and there's this real question too about the likelihood part of Brandenburg. And if you are a speaker in a position of power, does that increase the likelihood that your speech will lead to that imminent lawless action? And that's why, there's some reasons why, a criminal prosecution here that was appealed to the U.S. Supreme Court might give us a precedent that would, it's just, in a lot of ways, it's a unique set of facts. And would it make good law to be applied to the vast majority of other speakers where this question might arise?
Agreed. Yeah,
I'm
just
just-
because
I
I
think
think,
that-
yeah, I
I'm
think he
sorry, go
did
ahead.
it, but I don't think he'd be convicted necessarily. But I do think he did it.
Bethany,
I
I
have
think you have
no
another one.
doubt.
Go ahead and go to another audience question from Bethany.
Okay, so one more audience question says they're asked about a lawsuit filed under the Kkk Act, and they wanted to know what that was about, and if you could talk about that a little.
I don't know. I'm not up on that.
I think that's the law, the civil suit that was filed. There were a couple of members of Congress, I think, who joined that. I don't know about the details of that filing, so I can't speak to
No, neither am I. I don't want to fake my way through an answer. I just don't know.
So the Kkk Act is, I looked it up a little bit when I was, because it's about insurrection. And this is a Kkk Act of 1871 that I think they're referring to. And it's about, this all came about after the Civil War, and this is all in the context of the 14th Amendment. And like there's an insurrection clause in the 14th Amendment. So this is a law about, not engaging in insurrection, which is overthrow of your own government, which is the opposite of treason, which is not the same as treason. Treason is when you do it because you're trying to help another foreign power, whereas insurrection is you're just doing it for yourself and for, because you don't like the current government, and you could be wanting to do it, because you think it would be better for your own country. It could be patriotic in a way, but insurrection is, when you try to, through violence, overthrow your own government or impede its ability to carry out its functions. So I think that's what that case was about. I think it's an insurrection case.
If I could ask one more question about the long-term impact and global impact of Brandenburg before we move toward wrapping up. It does seem that some of the hate speech laws that have been around in Europe are starting to give way towards something like a Brandenburg criteria. Am I seeing that correctly? And do you want to give that one first to you? I know that's an area of your expertise. Are they starting to lean more on something like the Brandenburg test?
So I haven't looked at this in very recently, but I can speak to what the law is generally. So on the European Convention on Human Rights, there is a right to freedom of expression, but it's explicitly balanced against state rights. By state, I mean the individual nations that make up the European Union. Well, the Council of Europe, that's a different entity. I don't want to get into it. It's super complicated. But basically because there's a balancing between the the state's interest in various, there's like a list of things that the state can have an interest in that will get balanced against the person freedom of expression. And one of them is protecting the rights of others. So this idea that that offensive speech in Europe, at least under the European Convention on Human Rights, can be, you can actually restrict or censor speech because it's offensive to other people. So that's what the balance gets struck very differently in Europe. At least historically, but it's also very dependent on the unique history and culture of the individual nation. For example, in Germany, they have a law that you can't disavow the Holocaust, whereas in this country, that would absolutely be protected speech, even though it's a lie. It doesn't matter, you're allowed to say these things. Whereas, especially in Germany, they're like, yeah, we can see why you might not want that. Specifically you, Germany, with your history. Whereas perhaps in other nations in the Council of Europe, they would not allow that. They would say it was a violation of freedom of speech. So it's complicated by, the nature of the Council of Europe and this explicit balancing. And I think we do that in this country too. There's some balancing, but it's explicit that you are allowed to balance speech, someone's right to speech, against a certain a list of states' interests.
So again, the Germany law with regard to Holocaust, it's an issue of context,
Yep.
which takes us back once again to the Brandenburg test.
That's exactly, and it's deference that the European Court on Human Rights will give to the individual nations to kind of set their own policy based on their own unique history and culture, and so deference is given in that respect to the context. Yeah.
All right. Well, this has been fun. We've much enjoyed the contributions of all of you, and I just want to invite each of you to offer final thoughts before we wrap up. And so maybe we'll go in the same order with which we began. Alan Beagle, do you have any closing thoughts?
I have closing thoughts about the First Amendment in general. It's probably the centerpiece of our document, though that's debatable. I tell my class the first day that the First Amendment assumes a certain maturity on the part of the American people. And just because it's constitutional doesn't mean it's appropriate for you to say it. The First Amendment appeals to our better instincts. I'd like to think so. It's an aspirational part of the Constitution. And I'm so bullish on the First Amendment. I really am. Take the chance and let the speech be aired and let the chips fall they may, rather than mass censorship. So Brandenburg or whatever, I love the First Amendment.
Thank you. Eric, Casper.
I agree. I think that, our experience, especially when we look at the Supreme Court in the earlier part of the 20th century, should give us pause for tinkering with what is there in terms of any of these tests that are protective of the freedom of speech. And I go back to some of those major dissents. There's one line that Holmes had in Gitlow versus New York when he's in dissent, and he says, every idea is an incitement. That's what we're talking about here, right? The exchange of ideas. And of course, there are, even if we buy into the marketplace of ideas metaphor that Holmes really places squarely into First Amendment jurisprudence, we know that sometimes there are market failures, right? And actual imminent lawless action, incitement to imminent lawless action, could be a case of a market failure if we're following that metaphor, and a place where we can curtail that expression. But I think the message from that history and from the current Supreme Court, which I agree with, is that those categories of unprotected expression have to be narrow and they have to be well defined so that we're not trampling on people's ability to have that free exchange of ideas.
All right. So much there that we can pursue further another time. I think we're going to have to. Joanne Sweeney.
Thanks. I'm going to agree that whatever exceptions we have to the freedom of expression to the First Amendment should be narrow and well defined, but I do think they should be updated as communication changes and the reality of how we talk to each other, and what things mean. And I think context can help a lot with that. But I will say that with that we need to be very careful as we update these definitions or perhaps expand these exceptions to the First Amendment, because if you look at the history of incitement in particular, it shows that, you know, it can be used against causes that we very much think should be protected today. And I think the Supreme Court is very reticent, and rightly so, of getting in the business of deciding what kind of speech is too dangerous, right? So without these narrow channels to kind of, when it, you know, where do we come in and stop the speech? It can't just be because we don't like it, because in the past, what we didn't like is things that we think are very important today. And so I think that this is a balancing act that needs to happen.
All
We'll
right.
never get an answer.
That's great.
We defined for time immemorial. We'll never figure out. Beyond this point, you may not speak.
Yeah, agreed.
Well, I want to thank each of you, and also to thank Kara Orbell and Bethany Kreklow for sorting through all of the audience questions. You did a masterful job, as usual. Thanks to Tim Scheel at the Center for the Study of Institutions and Innovation at UW-Stout, and thanks also to the Menard Center for Constitutional Studies at UW-Eau Claire. I should have said Tim Scheel is at the Menard Center for the Study of Institutions and Innovation at UW-Stout. So thanks to all of you for being with us. And again, thanks especially to our panelists, Eric Casper, Alan Beagle, Joanne Sweeney. This was a treat. Thanks very much.
Wonderful time. Yes.
Thank you.
Good night.
Thanks.
Good night.
Night. Thank you all.